everyone. Today we have attorney Jillian Pickett, who's going to go over Probate 101 with us and avoiding common mistakes and expenses of probate. Now, Jillian, please take it away.
Yeah, thank you for the introduction. So like she said, we're going over Probate 101. So if we could have the next slide, please. So just a general overview, this presentation is only a general overview of estate planning and should not be considered legal advice. You should consult an attorney in your state and determine all of the legal requirements of your individual situation. Next slide, please. Right, so to start, we're going to talk a little bit about what is probate. So probate is a public process. Family grievances are aired in a public forum. It's necessary with or without a last will and testament. So having a last will and testament does not automatically avoid probate. It is time consuming. It's expensive. There's lawyer fees involved. There's court filing fees involved. You are often waiting for the court to actually issue the final decree or issue your appointment as personal representative. So there is just a lot of other parties involved that change the amount of time and the expense that probate requires. Next slide, please. So typically, these are some reasons why you would maybe need to probate a decedent's estate. One, if you are trying to find out if a decedent's will is valid. So if you're unsure if you have the correct version of the will or if you only have a copy, you might have to probate in order to determine that. You may also need it to change title or ownership of real estate, personal property, bank accounts, stocks, bonds, anything that was really in the decedent's name alone without any right of survivorship or pay on death beneficiary type is going to have to go through probate in order to pay the decedent's creditors. So if there's creditors who have brought valid claims against the decedent's estate, then you are also going to have to do probate. Get the decedent's medical records. Oftentimes, doctors won't give you the medical records after someone's passed away until there is a formal appointment of a personal representative. And then lastly, you may also need it to file the decedent's tax returns or to pay their taxes. Next slide, please. So when is it not necessary to probate an estate? So as we talked about before, whether an estate has to be probated really depends on how the property is owned when a decedent dies. So some examples we've given for when it might not be necessary to probate all or some of the decedent's property. So if it was jointly held, where there was a right of survivorship. So this could be bank accounts. If you have joint owners on bank accounts, it could be property as long as there is a right to survivorship with that joint owner. It'll automatically transfer then to the joint title owner in that situation. Proceeds from a life insurance policy, a bank account, a retirement account, that has a named beneficiary on it. That's not going to have to go through probate. It's going to pass directly to the person who is named as beneficiary on that account. And they might have to give that bank more information about themselves in order to get that asset and more information about the decedent, but they're not going to have to go through the whole probate process. And then finally, property that's held in a trust created by the decedent. So if a home is in a trust, if a bank account is in the name of a trust, then all of those, that means it's not going to go through probate. It's going to pass directly by the terms of the trust. Next slide, please. So a little bit about the process. So the start of the probate process is getting appointed as personal representative. So if someone's going to have to file the necessary documents in front of the court to get their appointment as personal representative. This is also going to be when they're going to admit the last will and testament to the court if there is one. That process can take around 12 to 15 weeks, depending on the court you're in and depending on the different circumstances of a case. After you're appointed as personal representative, then you will be able to gather the decedent's assets, sell their property if needed, and put it all into a singular estate bank account. After that, and once 1 year has passed since the decedent's date of death, you'll be able to close the estate with the court. This is a it's still a longer process. It's still a public process. You have to tell the court usually everything that came into the estate account, everything that was paid out of the estate account. They will really see everything. It's public record, so everything is on there. Who gets notified? So throughout this process, there's going to be many people who have to get notified. They are going to be the heirs of the estate, so the people who would take from the estate in the event that there was no will. So this is usually your closest living relatives, which sometimes is a surviving spouse, sometimes it's a child, sometimes it's a first cousin. It really just depends on who your closest living relative is. And then it's also going to be your beneficiaries of your estate if you have a last will and testament. So any person that you were leaving property to in your last will and testament is going to have to get notified at that time. There may also be some state agencies that have to be notified throughout the process. We practice in Massachusetts, so the Division of Medical Assistance Estate Recovery Unit has to be notified here in Massachusetts, and that it does our mass health recovery. So if someone was on mass health, it would give them the opportunity to file a claim. Also, sometimes the Attorney General's office needs to be notified if there are charities as beneficiaries of an estate. How long does it take? We kind of went over that initial process. Usually takes about 12 to 15 weeks. The full process takes around a year, if not more. Some estates have to stay open for a lot longer than that. And the final question we have on the slide is, when do heirs receive their inheritance? So they are going to receive their inheritance at the close of the estate, which is that 1 year mark. So it is a very long time usually before heirs receive anything from an estate. Next slide, please. So to go a little bit more into wills, the last will and testament is only effective at death, and the estate will still have to go through the public probate process, which creates some delays because, like we said, they have to stay open for 1 year from date of death. If you die without a will, however, you are going to be considered dying intestate. This means the property will be distributed according to the laws of the state, which is usually your closest living relative. So this could mean if you don't have any a surviving spouse or children or surviving parents or siblings, it could be going to your first cousin. So if you don't want that to happen, it's a really good idea to have your last will and testament in place and have who you really want your property to go to. You're also opening the will to arguments. It has to be filed on public record. Again, all interested parties are going to be given notice. And it's very, very public. Anyone, especially in Massachusetts where we are, anyone can search a court docket and be able to open up someone's last will and testament. Next slide, please. So some of the risks of a will-based plan are that they don't provide for incapacity issues. They have to be probated, so they still have to go through this public process. They may be problematic if they cross state lines. So if someone has a will executed in a state and then moves to a different state and they don't update their will, there might be issues with probating that will. Wills do not control all of your property as well. So again, if you have named beneficiaries on something, it's not going to pass through the terms of your will. The will provides direction and protection for a short period of time, and it cannot be for like the length of the lives of the surviving spouse and children and grandchildren. So it's not going to have a like long-term plan for them. And they are more susceptible to challenges as well because you're putting it on this public forum that everyone has access to and can pull these documents off of the court website. Next slide, please. So how to avoid probate? Again, a lot of people think that if they have a will, they're avoiding probate. That's not the case. The will only directs how the probate's going to go. So main ways are having beneficiaries on accounts, having a transfer on death beneficiary. That's what TOD means. Sometimes it's called payable on death beneficiary, POD. Joint ownership of assets. Make sure that they are joint ownership with the rights of survivorship. owning things as tenants in common usually is not going to avoid probate. And then trusts. Trusts are a really great way to avoid probate. Next slide, please. So what is a trust and when is it the right time for you to create your own trust? It's a private document between you, your trustees, and your beneficiaries. And you might want to consider this if you want a plan that will take care of you during your life. You want to keep control over the plan during your lifetime. And you want to outline what will happen in the event of your disability or in the event of your death. So this can also allow you to put in how you want to be taken care of and who will make decisions for you on your behalf. Next slide, please. And also, again, to control distributions to your descendants. You can also like make it so it goes in stages or it's only for their health, education, maintenance, and support. You can make lifetime beneficiary controlled trusts to really make sure that those assets are managed for their future. And it protects the beneficiaries from creditors, predators, and divorce if it's properly drafted. Next slide, please. Revocable trusts. So revocable trusts are a great way to avoid probate. It's an excellent estate planning tool, a tax planning tool for married couples. There are ways you can lessen the estate tax burden just by using a revocable trust. It's easy to amend and you still have control over it during your lifetime. I always tell people that it's a fancy way for you to own property in your own name. Although it still allows you to avoid probate. The main downside is that it does not protect property from a mass health lien or from creditors because it is still essentially in your name, even though it's in the name of a trust. Next slide, please. Irrevocable trust. So this is another great way to avoid probate. It can also remove money from your taxable estate. And when it's drafted properly, it can protect property from a mass health lien or from creditor claims. Life insurance can also be placed in a specific kind of irrevocable trust called an irrevocable life insurance trust. The main downside of this is you lose a lot of control over the property. So in this one, it's not a fancy way for you to hold title in your name alone, essentially. It is a way for you to give up control so that you are getting that added protection of avoiding tax liability and mass health creditor. However, there is also a 5-year look back for mass health. So once you create this trust, you still have to get beyond the 5 years to be able to have that claim. I'm gonna redo that. Redo just that last little part. So it is still subject to the mass health 5-year look back, which means you have to get beyond the 5 years before that the assets in the irrevocable trust are not subject to a mass health lien. Next, please. Okay, so here's a little bit of what you should do when a loved one dies, and we have a great ebook on our website that you should definitely check out if you are going through something like this. Within 2 to 3 weeks, you should locate your loved one's last will and testament and or their trust if they have it. Find out where their documents are located if they're with an attorney's office. Give that attorney's office a call as well. Collect all the latest bank account statements, titles, deeds, life insurance policies, any papers that you can find relating to the property that they own is going to be very helpful into determining if a probate is necessary or if a trust administration is necessary. Don't forget digital accounts. We are in the digital age now, so make sure you have access to their passwords. They might have accounts that are just purely digital. They're not receiving physical statements for these. It's really important, and a lot of people often forget about these. So make sure to be accessing those as well. And then finally, contact a probate attorney to discuss the estate and its administration. Trustees' duties, if there's a trust, there still is an obligation, even though it's a little bit faster and out of the public eye. A trustee still does have duties, taxes, and they'll just be able to answer all of your questions and bring you some peace of mind in terms of what the next steps are. Next slide, please. Thank you so much for coming today. Do we have any questions?
We have a question. How quickly can you start a probate process?
So usually the process can start as soon as a person has passed away. Some states have different rules of a waiting period after they pass away, but it's usually only like about 30 to 40 days after their death, and then you can get everything on file with the court to get them appointed as personal representative. But an attorney can usually start that process, and they would know the time frame within your state as well.
Another question from the box. It is, can you be both a trustee and a beneficiary of the same trust?
So you can. It depends on the type of trust, though. For a revocable trust, you can be the grantor, which is the person who creates the trust, the trustee, and the beneficiary of the trust during your lifetime. However, what you would want to name other beneficiaries for after you pass away. For an irrevocable trust, you cannot be the trustee during your lifetime, depending on the type of irrevocable trust you're trying to set up. You might have some rights as a lifetime beneficiary, but it would be set up a lot different because you are giving up that control of the property, as well as you're getting that added bonus of the creditor protection.
Another question. How long does probate take if you don't have the proper documentation, such as a will, in place?
So if you don't have a will at all, it might end up taking the same amount of time. You're just going to be filing intestate, and it's going to be going to your heirs at law. If you don't have a copy of the original, or if you don't have the original will and you only have a copy of the will, then that process usually takes longer because it's subject to more scrutiny by the court. And oftentimes has to go to judicial review to make sure that there's no other reason that this wouldn't be a true copy of the will. So it's always best to hold on to the original will if you have it, and make sure that you have a clear place that all of your documents are, so that your children, your future executor, personal representative is able to access that document.
All right, another question. When is the best time to bring it up to your family to set up a trust?
Yeah, I think it's always a good time to bring up setting up a trust, especially for probate avoidance. Definitely, if you own real estate, a trust is a great option to hold that real estate, and to make sure that you are successfully avoiding probate. As people get older, obviously, as well, probate avoidance becomes a higher priority for them. But I don't think it's ever too early to call an office, set up that trust so that you can avoid probate and have that peace of mind that it's not going through this public, expensive, lengthy process.
Great. Thank you so much, Jillian, for spending your afternoon with us and teaching us about the pitfalls for probate.
Thank you for having me.